Look, Advocate Shaun, you have come before this portfolio committee to answer a specific question and some general questions that are related to that. Being the arrest or serving of summons to charge the Minister of Finance and circumstances around that. That's a specific question you have appeared to come and answer. And would want you to spend fairly enough of time to answer questions that come from members of the portfolio committee. And in your introductory notes, you mentioned various organizations that laid or lodged complaints and some written letters to yourself, and that organization is represented in this house. It's a legal entity which enjoys more than 1.1 million support of South Africans who have expressed interest and confidence in that party. It's a legal entity. It operates under legal constitutional environment. And that organization is the Economic Freedom Fighters, not the Economic Freedom Front. You have attempted to reply to various questions put before you by my colleagues here. And in answering some of these questions, let me put to you that despite your current claim that you know the provisions of both the Constitution as well as the provisions of the National Prosecution Act, I doubt if you have ever spent enough time to read and to familiarize yourself with the powers vested in you, powers which you refer to as original powers. Had you been familiar with those, you would have acted differently. And the circumstances that we're faced with would have been avoided. Now, you are saying the Minister of Finance, Honorable Pravin Gordhan, is not a special. Did you say so?
I said that only answers will come at the end. Please put questions based on what you have heard, and you can do that on what we have not heard.
Considering that he's a Minister of Finance and his role plays so much of a greater part in not only our economy but on the socio-economic, political stability, you would have thought much about the manner in which your office in interaction with various other organs, such as the Hawks, should have approached this matter, including the manner in which summons were served to the minister, to an extent that in his absence away from home, when the Hawks knew very much where to locate him from, chose to go to his family at his private residence, intimidate his family members, cause so much of trauma on the eve of the most important budget statement which the minister was due to make. I want to put it to you that you owe the minister some apology. Both your action and that of the Hawks lacked basic human decency. That's the first thing. The second point I want to make is that you are saying you were called to meet with the Minister of Justice at the venue which ordinarily you would have chosen not to have had a meeting at such a venue, because that venue happens to be the Tuli House. It was within your right to advise the minister of your considered view, and you failed. And you cite a host of circumstances and reasons why you felt compelled to accede to the request from the minister, among which was that we were to meet with a security cluster of ministers. You were unaware that the president would be present there. So it was a coincidence that the president happened to be part of those that you met, to consider what was perceived as a state of complete anarchy as a result of the fees must fall, university student protests. I want to put to you, and in putting to you, remind you of a poet by William Butler Yeats in his Second Coming, which he talks at length on the subject of anarchy, since you introduced the concept of anarchy. Written under Things Fall Apart, the center cannot hold. I want to put to you that the anarchy you are referring to is as a result of state-inspired action and its failure to appreciate socio-economic situation, especially of university students, in relation to the fee question. And that the anarchy you are referring to has been loosened upon the world, as it indicates, by the state, and for which your office is part of that state. So before you point fingers to anyone for being responsible for instigating anarchy, it's fitting that you admit and you accept that anarchy in this context is state-inspired, and your office is at the center of playing part of the anarchy. I want to put before you that among the 5 concerns that the Economic Freedom Fighters Secretary General Godrich Gadi wrote to you and elaborated on, amongst them is the whole question of the unlawfulness of the charges leveled against the Commander-in-Chief on the basis of unlawful, apartheid-styled Rioters Assemblies Act number 17 of 1956, which is unconstitutional, which essentially is a continuation of the apartheid-styled anatomy of repression, persecution of political opponents, with consequences, Advocate Abrahams, of institutionalized state violence. And this is the continuation along the same line. And seated here as a member of this House, with an obligation to see to it that never again shall this country be subjected to any form of unlawful an unconstitutional legislation or act of parliament, I exercise my duty to remind you once more that an act such as that, enacted under apartheid era, in terms of the universal world community, is just as unlawful as was apartheid declared crime against humanity. And yet today you have invoked such law to charge the commander-in-chief for saying things that he said with his mouth. And let me remind you, this is not a coincidence, but it's a systematic, orchestrated state attempt to intimidate its political opponents, including an attempt to intimidate the Minister of Finance. Now, I want to put to you the following questions. Having realized that you are empowered by the Constitution as well as the National Prosecution Act with their various provisions, why, despite it was apparently evident that the charge against the minister would not stick, let alone the charge seeing a successful prosecution, at the time when you're supposed to have reviewed your decision, and I don't take your excuse that you had no sufficient evidence upon which you could have revised or reviewed your decision to charge the minister before this past Monday. I don't take that. It's a lame excuse. It will only be so, and perhaps consider your excuse, if your delay to review your decision to charge the minister was not preemptive and was not based on malicious consideration other than to be based on the law. Now, I hope you'd still have time to reply to the letter the Secretary General of the EFF wrote to your good self. Seeing that you say you were familiar and fully aware of the provisions of the NPA, and particularly Section 179, subsection 5D of the Constitution, read together with the NPA Act, that we are familiar with those provisions, why didn't you act swiftly to review the charges? And I want to believe that you were quite generally not aware of that you were empowered of such primary and original powers. Noting that you only considered to review such a decision to charge the minister after facts. I want to put to you again that you have failed to uphold the code of conduct of members of the National Prosecuting Authority. You have failed to uphold it, and as a result, in contravention with the very code of conduct and in contravention with the National Prosecuting Authority Act specific provisions that requires of you to act and to discharge of your prosecutorial responsibilities without political considerations. I want to put before you that you have put the name, the good name of the NPA and the entire judiciary into disrepute, and further breached the NPA Professional Code of Ethics, as I've already indicated. For all of this, Mr. Abrahams, I want to put to you that and this is not a view that the economic freedom fighters hold, but because of systematic blunders bordering on wanting to bring the office into disrepute to appease your political those who appointed you, and to appease those that openly or covertly. And I want to, and in this case, use this very moment to answer your rhetorical question about who could attempt to capture the NPA. Those who would want and have ambitions to capture the NPA are those who have got no respect for the rule of law, who have got no respect for the Constitution and the principle that underpins our democratic system. And those are the ones who would want to capture the NPA and undermine our national sovereignty and sell the sovereignty of this country to the highest bidder. And those have got no respect for the rule of law. And these are the guys who operate in clandestine, who are more of a political syndicate. And you have been bending forth and backward in taking orders from them. As a result, I want to put to you that you are unfit to hold office, and I want to put to you that you ought to be debarred as an advocate, and you have dishonored the office and the profession for you to continue to hold office. And I want to put to you, you deserve of nothing else and to be honorable, just as your predecessors, especially in this case, Honorable Bulelani Ngcuka, who resigned without being pushed upon committing a mistake similar to the one that you have committed, to declare prima facie evidence and make a person to be judged in a court of public opinion without testing the veracity of the allegations leveled against that individual. He resigned without being pushed. My advice to you is, do the honorable thing, don't wait to be pushed, and resign because you have dishonored the profession, the office of the Director of Public Prosecution.
Honorable Matiase.
You have disgraced the whole nation by the kind of a decision that you have made. So you are not fit to hold office. Lastly, don't blame it on anyone else. The hostile environment that exists in this house and outside is of your own making and the making of your handlers. And we will never allow this country to descend in anarchy, especially anarchy-driven.
Yes.
Honorable Chair.
We offered you an opportunity to put questions and not to cast aspersions on the personality of the advocate.
I'm putting questions. I want to put to you Lastly, that you should take personal, individual responsibility for bringing the national prosecution and the criminal justice system and the country into disrepute.
Whether or not there is a state-inspired anarchy in this country is a debatable political question, and it must be left to the appropriate forum for discussion. The economic freedom fighters.
Honorable Chair, on a point of order.
I'm addressing the committee.
On a point of order, Chair.
What order?
Can you please not mediate in the input that I've made and only use your space and time to comment after an appropriate answer
freely,
has been...
I allowed you freely to express yourself.
Has been...
I have to guide this committee. I'm saying whether or not there is a state-inspired anarchy is a debatable political issue that must be debated in the right forum. And I also need to draw the attention of this meeting to the fact that the submissions that you made are made in the letter to the General Bar Council requesting that Advocate Abrahams be removed from the role of practicing advocate. And that in response to your letter to the Bar Council has undertaken to appoint a panel of advocates to hear the very issues that you are raising, and you have been requested by the Bar Council to make representations to it to hear your request to them. So I think that you have already raised the matters in another forum, and so let's not duplicate processes. Here we have a different focus altogether. Your matters will be dealt with by the General Bar Council, not by this committee. Thank you very much. Over to you.
Thank you, Chairperson. Mr. Matiase, you asked many questions and you made many lengthy statements. The first issue that you raised relates directly to the Minister of Finance. In respect of me owing the Minister an apology. Our Constitution provides that everyone is equal before the law. And I don't deem it necessary under these circumstances to tender an apology. I have addressed the issue of the venue, the meeting I attended at Luthuli House. I've addressed that during a previous response fairly comprehensively. I don't endeavor to repeat it. I vehemently deny that the NPA is part of any state-inspired anarchy or action. A mere statement to that effect does not suffice. The institution is there to uphold the rule of law, to give effect to the rule of law and the Constitution. And we will continue to do so, irrespective of who the accused is and what station or status he or she holds in life. the Riotous Assemblies Act has not been found to be unconstitutional. That act is still applicable. And until it is set aside as being unconstitutional, that law remains. I've explained fairly comprehensively, both in my initial briefing to the committee this morning, as well as during the questioning of, during the responses to questions, my powers, how the decision to prosecute was made. It was made by a director, a special director of public prosecutions.
Don't repeat what you have said. It's on record.
If me reviewing a matter and giving effect to the NPA Act and the Constitution is in violation of the Code of Conduct of the NPA and my responsibilities, I certainly cannot see any merit in that. I deny having put the good office of the NPA and the legal profession into disrepute. I deny that this was a blunder or part of a systematic blunder. At the inception, when the initial decision was made to prosecute, there was a case. I made that much clear. I've outlined that fairly comprehensively in a media briefing. I did so again on the 31st of October. The Chairperson, I don't have any handlers, so I can't comment on that.
Thank you. Honorable Mwabe.